Hello and welcome everyone to the Indian Youth Economic Association's The Agenda. Today we have perhaps the largest panel that we've assembled for any of our podcasts up until now. And we're discussing an extremely complex as well as relevant issue. But before I get to the substance of the matter that we will be discussing today, I will be introducing our panelists. We have with us, first of all, Mr. Shubhendu Anand, who is partner at Atharv Legal, who has worked at the office of the ASG, Mr. Vikramji Banerjee, as an associate counsel. And his primary areas, apart from constitutional law in terms of legal practice, are taxation, regulatory practices, and intellectual property rights. Shubhendu is also a shedding scholar. Welcome, Shubhendu. Pleasure to have you. We have with us, obviously, Mr. Satvik Issar, who conducted our last session on the constitutional law and the law on the original jurisdiction of the constitutional courts and the law of writs, who is presently an associate counsel at Veritas, primarily practices at CAT, that's the Administrative Tribunal, and the Delhi High Court, is an associate counsel at Veritas with Mr. Vimal Kirti Singh. Welcome, Satvik. Pleasure to have you on board with us. We also have with us Satya Sabharwal, incoming advocate, enrollment still pending, but he has extensively worked on matters pertaining to religious freedoms in India, particularly Articles 25, 26, and 31A. He has filed, drafted, and been a petitioner in many of these matters across high courts in the country, including the Supreme Court of India. And he is an author, he's a co-author with Dr. Subramanian Swamy on a book that deals extensively with the Ayodhya judgment and the history of the issue. So welcome everyone. Today, before I get to the specifics of the issues that we're discussing, the issue that we're discussing today are the religious freedoms in India. It's important to note on some level that what the date is today. It is the 2nd of August. Now, for students in history, such as myself, we would take a keen interest in the fact that it was on this very date in 1858 that Queen Victoria gave her assent to the Government of India Act. And this Government of India Act, in a sense, forms the first one in 1858, 2nd August, forms in fact the broad structure of the modern polity as we have. Obviously, this evolved over various Governments of India Act, and ultimately from that we derived our constitution. But there's one fundamental change that the Constitution of India makes from any other Government of India Act which does not have it. And that fundamental change is fundamental rights that effectively make us free and make us sovereign. And within fundamental rights, sure, they've been changed, they've been altered. There's been a lot of discussion in terms of the constitutionality of amending away fundamental rights. But two specific articles in the Constitution, which have not faced that kind of scrutiny from Parliament in terms of being amended ever since the Constitution was passed back in November of 49, are Articles 25 and 26. And that is the starting point of the discussion for us here today. We have before the Supreme Court of India presently, and perhaps the bench will be reconstituted in this regard, before a 9-judge bench, certain relevant questions of law pertaining to the broader scope and ambit of Article 25, 26 and religious freedoms in India. It's interplay with other fundamental rights and the sort of scope of this. So I would like our panelists to begin with their views on the scope, the ambit, and the broader sort of jurisdiction of 25, 26. What is the scope of these two articles and of fundamental rights in this regard? So I'd like to begin with Mr. Shubhendu Anand first. Shubhendu, most welcome.
Thank you, Ajay. I'm really glad and very heartened to hear that you are hosting this very important seminar on right to freedom of religion in India. And what better than young minds discussing this? And I'm fortunate to be a part of this panel. It's really heartening that to know that IYEA is hosting such important seminars which are aimed at educating the larger populace, and also setting a narrative, which is kind of a scholarly narrative is lacking in our system. So to begin with, Article 25 and 26 have been largely debated in our country, and they have been debated at an extensive level since the Sirur Mutt case. So the history, if we trace the history, the constitutional history of 25-26 in the Supreme Court traces back to 1950s. But before we go and discuss these cases and what entails from these cases, what exactly are 25 and 26? One is freedom of conscience and free profession of religion, which is 25. Now, in India, the Constitution guarantees you a right to profess your religion, to believe in your God, and to practice and propagate your religion in the way you like it, subject to it not invading the other rights of other people. That is one. And two is that while you do so, you also have the right to manage and administer the religious institution and the religious activities, which is under 26. So these two parts essentially form the basis of what we call the religious freedom in India, wherein one, you have the freedom to practice, profess and propagate your religion, one, and two, that you have also the right to manage and administer the educational and cultural center, religious affairs, basically the religious affairs of the country. But one thing that I was reading, that while doing so, what essentially is profession of religion? Is it a random belief in something? Does that constitute to your belief system? Can it be protected under 25? I think that question is dealt with the larger test, what we call as the essentiality test. And in essentiality test, some of the important factors are the test of time, the test of continued practice. But at times there have been, this is what I wanted to bring in, and it always keeps on troubling me, is that the courts have now gone on to test the rationality of one's faith. Now, it is not the court's duty to test the rationality of one's faith. My faith can be in a stone, my faith can be in a book, my faith can be in a statue, my faith can not be in anything. It could be in a vacuum. But can the courts judge that rationality of my faith? I think no, the courts cannot judge the rationality of my faith. The courts will only judge that whether that faith is validly held or not. So validity of my faith cannot be subject to judicial scrutiny. Whether that faith has been validly held or not, that can be subject to judicial scrutiny, because only then you will be able to ascertain that whether that is what I am holding as my belief is validly held in the sense that whether it has passed the test of time, one, two, whether it is basic tenet of the religion or not. I'm reminded of the Anand Margi case, wherein they claimed that doing the Tandavam was an essential practice of the Anand Margis. The Anand Marg denomination, if you can say, it was a part of the larger Hindu fold only, but the Anand Marg sect was established in the 50s. However, they adopted the Tandav dance as a mode of worship only in 1966. Now, on this ground, it was held that because the religion or the sect was not found on this particular dance, or the dance form did not form the basis of the founding of religion, one, and two, it was not practiced since the beginning of the faith. It was struck down that Tandavam was not around dancing on the Tandava, Nritya, and around the fire was held to be not an essential practice, and hence was they were restricted to do that. So So, so that is what my opening comments would be. Whether the courts can go into the rationality of faith. Of late, the courts have been going, but I think they should not. And two, what then what can the courts do? The courts can only check whether that faith has been validly held or not. So these would be my opening comments, and we will discuss the other cases and other issues as the discussion progresses.
Certainly. I think that's fitting as opening comments. Satvik, would you wish to add to that in terms of your view regarding 26, the broad ambit and scope?
Okay. Hi Ajay, hi everyone. Now obviously I will not go into the reading of 25, 26 as Shubhendu rightfully and very well has gone into. Now I have my understanding of 25, 26, 27 and 28. Now when you consider these four articles which predominantly deal with fundamental rights surrounding religious practices and religious denominations in India, we would see that 25 is more like the foundation. 25 states that you can practice, profess, and propagate your religion. And you can do it with freedom as long as you don't infringe on someone's personal rights. That is a very important aspect. And of course, if you actually read 25, the opening line to 25 is subject to public order, morality, and health. So 25 opening line is that it is subject to other restrictions. Now, when we see 25 foundations, we see it as a foundation provision, which then enables 26, 27, and 28. 26, which goes into the maintenance of religious institutions and the freedom of maintenance of religious practices. 27, which deals with tax surrounding religious institutions, and 28 goes into the educational aspect. Now, very, very interestingly, the law that exists as of today, as per the Young Indian Lawyers versus Union of India judgment, as the Sabharwal order. Now, in that, the Supreme Court, in a majority opinion, took this very understanding that 25 is the foundation, whereas 26 is the operating clause to some extent. So, while you can argue that the Devasanam board has the right to administer and practice their faith, the Devasanam board under 26 is still subject to 25 subclause B, which states that so I'll read 25 subclause 2 subclause B, which states provided for social welfare and reform or the throwing open of Hindu religious institutions for public order, health, morality, etc. Which basically means that under 25 2B, the court had a right to go into whether it was an essential religious practice, as Shubhendu has said. Now, when we discuss the relationship between religious fundamental rights versus other fundamental rights, such as the right to equality and the right to life, we must understand that we live in a modern democracy. So while we grant certain freedoms to religious institutions and religious denominations to practice what they feel, it is important that these practices come within the ambit of modern democratic values and modern democratic values of equality and untouchability, etc., things like that. So it is also important that all religious practices from all faiths, I'm not saying only Hindus or Sikhs, I'm saying Hindus, Sikhs, Christians, Muslims, everyone, all religious practices in India, because we are in a modern democracy, must pass the test of equality before it is implemented. So in that regard, the court has a right to interfere. But yes, the court does not have a right to question the rationality behind it. That is a point I would agree with Shubhendu on, and these are my opening statements and as the conversation proceeds.
Okay, thank you so much, Satvik. That's absolutely apt, and that will get the discussion flowing. Satya, we'd like to have you on board now. And
thank you. Am I audible? Right.
Yes.
So I'll start with saying that if we see the foundations of article from 25 to 28, which is religious of rights of freedom of religion, what we have to examine first, let's read the preamble. It secures the liberty of my belief and faith to worship. If you read the preamble, so that is the foundation of article 25 and 26, which is a very essential part of my rights under article 25. that is to propagate, practice my own religion, subject to Part 3 of the Constitution. What I would like to put light upon is certain practices that of the state, of the government, which have been advocated, and I've personally petitioned some of them in high courts, that government is taking over certain temples, and most of the temples, if we see from the south, most of them are codified there. They're taking over certain temples, and is that taking over of temple violating my Article 25 and 26 and other articles of the Constitution also? One thing we have to examine here is that when we talk about Article 26, first I'll talk about Article 26, then I'll come to the scope of Article 25. When we talk about Article 26, there's a word mentioned in the article that is religious denomination. I'll read if you want. Subject to public order, morality, and health, every religious denomination or section thereof shall have the right to establish and maintain institutions for religious and charitable purposes, to maintain its own affairs and matters of religion, to move and acquire movable and immovable properties, and to administer such property in accordance with law. So, if there is a religious denomination, can state interfere? And if state can interfere, in what capacity? There are two things where and one where state can interfere and one they cannot. If we read Article 25, there's a word mentioned as secular activities where state can interfere. But there are multiple judicial pronouncements where the distinction has been made, but still not clear what are secular activities and what are religious practices and activities, where state can interfere and where state cannot interfere. And if a religious denomination has the right to administer its own properties and temples and matters of or its own religion, to that if state can interfere or not. Is there any? Am I audible?
Yes, yes.
Yeah. So that has to be examined. Apart from that, slightly taking away from Article 28, there is also one article, Article 31A 1B, which says that state cannot take over any property for unlimited period. If they take over, that too they can only take over in public interest or in proper management. So that has to be also examined. If the state is taking over, and I remember there was this case where I worked also 2014. It's Dr. Subramaniam Swami's state of Tamil Nadu, where court in paragraph 65 clearly says even if the management of a temple is taken over to remedy the evil, it has to be returned to the original owners, and they cannot take over for unlimited period. And what I have seen in all the acts where governments have been taken over temples, one thing is common in all the acts. One, head is a government official. Second, all of them are in perpetual succession. Recently working on the Uttarakhand Char Dham Devasthanam Act, which I will talk about later. So one thing is common in all these acts, it's that all of them are in perpetual succession. Furthermore, which also we have to examine certain essential practices of religion, and if court can interfere in such matters, in what capacity they can and what rationale they can. So I'll be discussing all of that in upcoming discussion. Thank you.
I think we sort of moved beyond mere opening remarks now. And I think we're pretty much on the same page where we sort of take the discussion forward. And I'll be drawing from the opening remarks from Shubhendu and from Satvik. And we look at the sort of interplay here. That now the next question that arises out of this is, again, this is part of for our audience, this is part of the issues even framed by the Supreme Court for the 9-judge bench, is what is morality? When we talk about subject to morality, religion is to be followed. What does morality mean there? Within this, obviously, there will be a question of rationality. Right? Morality and rationality would, to some extent, would sort of go hand in hand. At least the discussion, I'm not saying that one means the same thing, but the discussion about rationality of faith and morality of faith sort of goes along with that. And to add to that further, there's this concept of constitutional morality, right, which has been sort of expounded upon specifically in the last few years. Sure, it sort of flows from Kesavananda Bharati, but over the last few years, courts have sort of expounded upon it, at least the last 4 to 5 years. further. So the question is whether morality here means constitutional morality. Now, even within that concept, how we take out morality, because the whole point of law is codification of morality in some sense. That's why we have a constitution. But at the same time, when we look at constitutional morality, we must look at it with the interplay of other articles. Right? When we look at, examine one article, what is its significance to the other? And that's why we look at 25 and 26, and we look at Article 14 and the role that these three articles sort of play in together, right? And this is something that has been of sort of much debate and much discussion. Also, specifically when it comes to the essentiality of a practice. So when we apply 14, when is it applied? When is it that courts can intervene or cannot? Because when we look at now we see sort of two views emerging, right? On some level, Shubhendu is suggesting that there shouldn't be judicial intervention at all, because courts don't have a duty to investigate whether religious practices by themselves are sort of rational or not. Just that they're held. Satvik says that, okay, fine, there is also a question of sort of public order, there is health, there's public health, and there is the broad, again, public order and health can still be considered more sort of tangible, material realities. But when we get to the question of morality, that's where I think the role of advocates and the role of advocacy and even judicial interpretation comes into play. And I think that's the point where I would now like to sort of go back to Shubhendu regarding the interplay between various articles and specifically between sort of equality and religious freedoms, 25, 26, and certainly within that, the developing field of essentiality of the practice within a faith. And what is its stature when we're examining these rights in conflict with one another, and if at all such a conflict exists. Shubhendu.
So Ajay, let me first deal with the whole idea of constitutional morality. To my mind, constitutional morality is nothing but it's a word which came into the fancy of the judges, the lawyers, the jurists in recent times, and they wanted to impose this through judgments, through their writings. The scholars wrote about it extensively. The judges gave judgments and quoted constitutional morality as one of the founding principles of what we call as basic structure. I don't think the founding fathers of Indian Constitution were very appreciative of morality, constitutional morality, because if you go back to the Constituent Assembly debates about secular, when the idea of secularism was being discussed, Dr. Ambedkar had said that he did not want values to come into the Constitution. The Constitution would be a book that would guide the country with laws, one, and two, towards the progress. It should not be binding people into values. So he wanted values to be out of the Constitution. So when we talk about morality, are we trying to impose value systems on people? Because if Constitution comes down to imposing values on people, I think that would be a problematic situation. So constitutional morality again should would not be a right approach towards discussing the whole idea of morality. Public order, of course, public order is very important and subject to public order and public health, because as you said, these are very tangible things. One can see that in the Rath Yatra case also in Puri. Because public health issue was involved, the courts rightly restricted the whole yatra and made only certain people do the religious whatever thing was going on, the procession. Again, that's an essential practice that had to be followed, and that was being followed. But again, subject to public order and morality and public health, yes, that was taken into consideration. Now, when we talk about the interplay of various constitutional provisions, specifically the fundamental rights into 25 and 26, I think we have to first and foremost make sure that 14 is complied with, 19 is complied with, 21 is complied with. Why? Because you cannot have a temple which restricts the entry of Dalits into it. You cannot say that no, it is essential practice of certain communities to only go and pray into that temple, and other communities cannot be. If it is a public temple, of course, everyone has the right to go into that temple. So you cannot have temples where Dalits are discriminated against and cannot go and enter there. You cannot have, at the same time, you can also not have churches which do not allow. I mean, I'm telling you a live case from Andhra, wherein Dalits who converted to Christianity, they have their own churches. They are not allowed into the churches which what they call as the usual normal Christians go and pray at. So you cannot have churches like that. You cannot have dargahs and places of Islamic worship where women are not allowed inside. So these things have to be taken care of, and these things have to be. So when we talk about 25 and the right and the essential practices test, I think it is very important to make sure that any essential practice that we are going to say that it is essential to the religion should not be discriminating against women, against Dalits, or against any section of the society. One. And two, that such practices, if they exist, they cannot pass the muster of the constitution. So it is very important that the judiciary therein intervenes and then says that, okay, this cannot be allowed because it does not pass the 14 or 21 test, because it is discriminatory. You can in a modern democracy, as we were your Ajay's opening comment was, and Satvik also talked about it. In a modern democracy where we are striving for an equal society, and we are talking about equality all over, we cannot have temples and churches and mosques or other places of worship where women are not allowed, where Dalits are not allowed. This cannot be. This is morally wrong. One, and two, it should be struck down on the 14, 19, and 21 test as well. So yeah, with 25 and 26 have to be tested on the fundamental rights and equality principles.
Okay, good. Satvik, we've had this discussion multiple times. Shubhendu has put across his view. Would you wish to build up on this further, on the clash between 14 and 25, 26, and 25 and 26 by itself?
Absolutely. So I'll start with constitutional morality. Now, when we look at constitutional morality stems from the social contract theory that we study. The concept of what a social contract that each citizen signs with their sovereign. Now, there are many different social contracts, but to break down the social contract that India follows is that there are basic freedoms of equality, freedom of speech, the right to life, freedom to religion, but all our freedoms have restrictions. And those restrictions are placed in order to maintain public morality, health, and order. Now, when we look at constitutional morality, we look at the basis of our Indian constitutional morality is equality. Equality for all and the right to life. And of course, various freedoms. So now let's look at the instances where Supreme Court has actually intervened in religious practices. Actually, before we go into that, I would like to go into slight historical aspect. Now, it is an unfortunate fact, but religion, whether it has been Hinduism, Christianity, or Islam, over the past 1,500 years has come up with many beliefs and practices which in today's modern democratic society are detrimental and unconstitutional in terms of equality for women. This is a fact. Now, whether we argue that these religious practices, even though that they have existed for 1,000 years, whether they fit in our fabric today, in our constitutional fabric today, because it is important for change. It is important for equality. So that is where the entire argument of 14 and other Part 3 articles come into the question regarding the right to practice religion. Now, when we look at the instances that the Supreme Court has intervened in religion in India per se, we can take Jallikattu, for example. Now, Jallikattu is a practice of bull racing in Tamil Nadu, which in a way is I won't say it's violent, that's wrong, but it is of a violent nature in the sense that people can get injured due to it. Now, in that case, the Supreme Court struck down the act of Jallikattu as it is harmful to the human body and society and public order in a way. Then, if we look at the issue, the very interesting case of Mary Roy versus Union of India. Now, in Mary Roy, what was the question? The question was in discussion was the Travancore Succession Act, the Travancore Christian Succession Act. Now, according to the Travancore Christian Succession Act, Syrian Christian women, a particular denomination within the Christian community, were not entitled to succession if there was no will. If their father, immediate guardian died intestate, women were not to be included because it was the belief among Syrian Christians that women don't have equal rights to property. Now, in this case, why did Supreme Court intervene? Because when you compare constitutional morality of equality and succession, how can you say that just Syrian Christian women are not entitled to succession, whereas the rest of the country is? So in such an instance, the court has no other choice but to intervene. In other instance would be now we all know that in our constitution, as per Article 21, we have a right to life, subject to procedure established by law, which basically means you have a right to life. The government has a right to take it away if they feel. But we don't have a right to die. Now, what does that mean? That means, that is also debatable, but we don't have.
I think that is pretty much been developed. Even the recent judgment, I think, with Justice Mishra. I think that right sort of exists within 21. I think that is fairly established.
No, when I say right to die, you don't have a right to commit suicide, or you don't have a right for someone to assist you in suicide. And why I'm saying this is in the context of the cases regarding the Jain monks. Now, we all know Jainism has Swatambaras and Digambaras. Swatambaras, the sky-clad, and the blue-clad. Now, there is a community amongst the Jains who, after a point in their lives, have a tendency to stop eating and stop looking after themselves, to periodically, basically, slowly commit suicide. Now, in this situation, the Supreme Court did intervene and say that, no, you cannot do this because you do not have a right to kill yourself like that. So, in such instances, and of course, in the Sabrimala judgment also, the most important, as Shubhendu has also mentioned, in a modern democracy, you can't have separate religious laws which do not meet the test of normal laws, because then you become a Saudi Arabia. You have two parallel laws working on the same aspect. So you have one law which says that women are equal to men in all aspects, and then you have another law that says, but no, women can't enter temples, churches, and mosques. That doesn't go hand in hand, and you can't do that because we don't live in a theocratic society. We live in a society that respects all religious practices, but at the same time, as long as those religious practices are not detrimental to society as a whole, they are allowed to exist. And that's the basic aspect of constitutional morality when read with Article 25.
Okay.
So,
I think that sort of sets the tone of the broader debate there. I'll now be getting to Satya. And Satya, sure, you can sort of comment on the broader issues that Satvik and Shubhendu have highlighted. That is, when is it that there is a clash? When is it that equality sort of comes into play? And once you've sort of touched upon that, you can we welcome your views on that. Then maybe we can also sort of steer the discussion and debate around, because we are on 26 and 25 here, on the question of state control of temples, and specifically because you mentioned it right at the beginning in terms of sort of 31A, and not even sort of 31A, but the core differences when we talk about, let's say, the secular function, what is sort of tangibly the secular function, and what is the administration of the faith. And certainly we can sort of discuss the Shabbat rights, and we can certainly discuss even, for that
Yeah.
matter, the very recent judgment of the Supreme Court, the 13th July judgment. And in that context, we can sort of, yes, precisely.
Yeah.
And then we can sort of, but we'll be open to sort of your comments, if any, on the sort of broader clash, the conflict between, say, 14, 25, 26. Right?
Right. So starting with 14 and 25, 26, when there's a clash of two fundamental rights. See, one thing you have to see when it comes to religious activities or religious essential practices, or in fact any religious for that matter, temple or practice, anything which is happening which is religious in nature, you have to understand it has certain ramifications and implications. When we talk about there's a clash between 14 and 26, we also have to discuss, are there any exceptions to Article 14 when they're in clash, or if there is any discrimination with respect to that. So there are two tests and two exceptions in that context, which I would like to discuss, and then later on go to the Sabharwal matter in which these issues have been laid down. One is intelligible differentia, and the other is a reasonable nexus. So first of all, let me clarify this, that the distinction of 10 and 50 age in the Sabharwal matter, the discrimination in that point of context, it is not on the basis of menstruation. So that is all perverted minds, and I don't know where that is coming from. So that is not the case, first of all. Second, there's no discrimination in all women. That has to be clarified. Now, to examine this, first we have to trace the history of the temple and the history of the Lord which resides in Sabharwal, Lord Ayappa. So Lord Ayappa, if you see, he was born to Lord Shiva and Lord Vishnu in the avatar of Morini. So that has to be seen. Apart from that, there are multiple temples of Lord Ayappa. There are more than 1,000 in Delhi NCR. And in that particular region, there are 4 temples. But Sabharwal is the temple where he resides in the form of brahmacharya, celibacy. That is the reasonable nexus here. He resides there in the form of brahmacharya. And there's also essential practice called Vratnam, which is a 41-day fast that men, they do there to worship Lord Ayappa. So what is the intelligible differentiation? That, see, you have to understand, there's the discrimination is not of all women there. It is very much restricted to 10 and 50, and that is not on the basis of menstruation. That is only basis of that the Lord resides there in the form of brahmacharya state, in the form of celibacy. So that has to be seen. Whether certain essential practices state judiciary can interfere or not, it's a completely different debate. I will come to that later. What also has to be seen, apart from the clash of 14 and 26, it has certain ramifications and implications. So courts have to be extremely vigilant when they have to form any opinion on this. It is a very sentimental issue, has certain values. So you understand, court has to be extremely sensitive and extremely on the basis of what customs are going on. And if you read Article 13(3)(a), it says customs do constitute law. It defines what law is. And this particular aspect of exclusion of women from 10 and 50 age is part of custom of that particular temple. Why? Because he's in the form of celibate, he's in the form of brahmacharya state, Lord Ayappa there. And coming back to Article 26, do that particular temple have the right to administer its own affairs? People who worship Lord Ayappa are called, the denomination are called Ayappa Swamis, and that was upheld by the High Court. And that particular judgment is not challenged before the Supreme Court. So that also has to be seen. Therefore, that particular judgment of High Court is in rem, which means it is binding. After establishing the denomination, do they have the right to administer its own temple, its own matters of religious affairs? Yes, they do have. They can very well do that. Second, what I would like to put light upon is that the locus standi, the maintainability of the petitions which was filed by the Young Indian Lawyers Association, if I'm not wrong, that also has to be seen. Do they have the right to file that particular petition if they don't subscribe to the customs and traditions of Lord Ayappa? That has to be seen. Now, Satvik very well said that a particular denomination in Christian churches, that's what he said. That's the line. See, you understand one point. When we talk about religious denomination, now where is this word denomination coming from? The 1954 Shri Math judgment, this definition was taken from the Oxford Dictionary, and we know it has a very westernized approach to that. So the denomination definition has to be through judicial pronouncement, has to be taken from the in the context of Indic point of view, which we have to through courts establish that. Apart from that, when we talk about religious denomination and state control, coming back to my point of state control, the particular thing which stops us is that Muslim are a religious denomination, Christianity is a religious denomination, and in Christianity, I would like to put across you that there are certain denomination, and there in one particular denomination they exclude the other denomination to enter. But that is not the case in Indic point of view. If we translate the Constitution, if you also invoke Article 394A for all authoritative texts, the translation of English to Hindi will also be of the same value. Then the translation of denomination is called Sampradaya. And in Indic point of view, Sampradaya, we don't exclude other Sampradayas from coming in that existing Sampradaya. So that has to be taken point of view when we talk about denominations. There's a judgment which says that Hindus are not a denomination, Muslims and Christians are. Oh, fine, Hindus are not denomination. They also say Shivites. I mean, Shivites and Vaishnavites are also not denomination. If you read Article 26, it says religious denomination or section or sect thereof. So that through judicial pronouncements, I think so it's very important. The first step to come into temple administration, of which I think it's the barrier, is that there's no religious denomination to give as per religious denomination definition Shri Math. Though Vaishnavite, Shaivites is a denomination if you take the Indic point of view there. Second, after the religious denomination definition, the second point comes, okay, fine. State control can be taken over unlimited period. They cannot take over. There's Article 31A, 1B. Then unlimited, there's 2014 judgment which says also. Then whom should we give it to? For that, I think so, court should not be the regulatory body, or the government should not be. There should be a district-wise committee set up where head should be the head of the temple of that particular district, or if there are multiple temples, then head should be the head priest of that particular temple of that particular district.
Getting some trouble with the audio for Satya.
Am I audible?
No, I think that last point has not been audible.
Okay, so my point was that when we talk about...
No, it's still not audible. I think you have to check your audio.
Just a second. Am I audible now? Am I audible? Am I audible now? Am I audible?
Okay. So
Satya, continue.
The audio from Satya's side. And we'll get back to Satya. We can just sort of check up on that side.
My point with religious denomination is that fine, if we don't have an established religious denomination, that
whom should we give? Have a vice committee, because religious affairs and these laws are something which cannot have a centralized unit like a Waqf board or the Gurdwara Act. So we have to have a district wise committee where head should be the head priest of temples coming in and then discussing what should be the matters of religious affairs and how you manage it. There's one more point which I like to bring and then elucidate later, is that the distinction between secular activities and religious activities. What are secular activities and what are religious activities? Well, one thing which I've seen in the Uttarakhand judgment is that the act says for decoration, Char Dham, the board which has been constituted for decorations and rejuvenation, they will interfere in all kinds of decoration, flowers and all kinds of activities, and appointment of priests and removal of priests. Is that a secular activity or is that a religious activity? So certain religious pronouncements have to be, certain petitions have to be filed with respect to this. So this is what I believe I'll be discussing later. And over to you, sir.
Okay. So I think there's probably some issue only on my side, but I think we've gotten that sorted now. Shubhendu, this is, and Satvik, I'd like you to come in as well later. Shubhendu, this is a slight divergence, if I may, from the earlier points that you and Satvik were stressing upon. And in that sense, sort of gives an alternative point of view, specifically with respect to the Sabrimala judgment. So is there anything that you would wish to add as a response to what Satya has mentioned? If there's anything specific that you would like to add in response, otherwise we can sort of move to the next question.
No, I think there's one point that I want to make is that mismanagement has been a very important debate in these times. Mismanagement of temples. Now, there are temples in South India and as well as in North India in which the power is concentrated in certain families, few families, while the temple are public temples. There are people who control the entire affairs of the temple, and there are certain families which do it in perpetual succession. So that is a problematic situation here. Then if that is the situation, what does the state do? Should the courts come and intervene and then decide what has to be done? Should the state be made to be a party in management of the affairs of the temple? I think that is one area that we need to really focus on and see what is an alternative. One. Two, that of late there has been cases where the old temples like Puri Jagannath, the Jagannath temple in Puri, they are not in a good state physically. They are turning into ruins because of the mismanagement, one, and two, because it has not been taken care of properly. The buildings are not taken care of. Now, in that situation, what does the state do? Should the state take control of the temple and then for the rejuvenation, should it constitute a committee or sit on a committee and do this? Well, in the court, there is this case which is still being heard in the Supreme Court, Mrinalini Padhi versus State of Odisha. Therein, the Supreme Court is contemplating on constituting a board of management of Jagannath temple in Puri on the lines of other temples like the Sai temple in Shirdi or the Vaishnav Devi temple in Jammu and the Harmandir Sahib in Amritsar. They are actually checking how does, or Tirumala Tirupati Devasthanam, that how these temple trusts function, and can a similar approach be adopted to Puri Jagannath temple. Now, why the court had to do it is because of two reasons. One, mismanagement, and two, neglect. Well, when the state neglects, the courts will intervene. When the people or the custodians of the temple neglect, the state and the courts intervene at times. So, and mismanagement, of course, as I said, that has become a very important and relevant topic to discuss these days in terms of temples, and concentration of power in certain families, in certain people who manage these temples in succession. So today they are managing, tomorrow their children would be managing. So can this be allowed, or is there a larger public participation from the devotees side that has to take place? So this is what I wanted to talk about in response to what Satya said.
Okay. So I think that's a very interesting point that you also mentioned, and Satvik, that's the point I want you to come in on. The question of Shivaite rights, right? Where, and we've discussed this at an earlier stage as well, and for the benefit of our viewers, I'd like to get your views on this as well. When it comes to a question of a particular family, in some cases, most cases, this has been an erstwhile royal family. We see that they continue with these Shivaite rights. Now, what we see from the law as it has been, I'm sure you can sort of stress upon this, and this is sort of dating back to the Privy Council days. And this is not even about denominations, it's about Shivaite rights specifically, that these are hereditary in nature. Right? If you also go back to the 13th July judgment by Justice Lalit and Justice Malhotra, they've emphasized on that part. The Goswami Shri Giridharjari judgment talks about the nature of the Shivaite right, and it's sort of hereditary in nature. And now that in a sense sort of conflicts with this point, and as Shubhendu sort of rightly mentions. Do you have sort of points of view that you'd like to put across regarding that?
Actually, I do want to discuss that. I would also like to reply to certain points made by Satya initially, but I'll first answer your question. Now, if we've seen in the Kerala Devised Board case, we see that the Shivaite rights was given back to the original caretakers. Now, in the Devised Board case, the king of Travancore was not the person who built the temple. It is believed that few hundred years ago, they took over the management of the temple. For the same reason was mismanagement back then. That today rulers of the Kerala Travancore family took over. Now, what is the judgment is basically recognize the Shivaite rights of the family. Now, I'm in complete agreement with Shubhendu on that aspect, but with a few more opinions. One being that we are seeing vast mismanagement. It's not that we are seeing very little. We're seeing it everywhere. I've been to Jagannath temple throughout my life. I have seen it. Okay, I have seen the mismanagement. I have seen the building practically breaking apart. And what excuse can they give? Lack of funds? That's impossible. That's almost hard to believe. There is no proper auditing of the temples going on. There is no auditing. There is no check and balance. Temple trusts are running completely free. Now, it is a folly to believe that temples in India don't wield a huge amount of influence. In a certain aspect, religious, and not only temples, religious institutions, there are masjids and churches which are also as powerful in this country. Religious institutions in this country wield a certain amount of power, and that is not only influential power but financial power as well. Because people of this country have a habit of donating. You are looking at not millions, you are looking at billions of dollars worth of assets with these temples, accumulated over hundreds of years. Now, who does this belong to? Where does this money go? Who manages it? Where is it being given? Is it being given back to society? Now you are in a situation in a country today where people starve to death because of no food. But you have temples filled with gold, which is more than supposedly the amount that is stored in Fort Knox in the United States. Where is the morality in that? So if there was no mismanagement, if there was no aspect of corruption, undue influence that is happening in the temples today, in temple trusts today, then we could say there should be no interference. But when we are looking at the interference that there is in temple management, it is only to the extent when there is clear, open mismanagement. And therefore, my belief in such a situation, in how to handle such a situation, is to set up committees like the court has been doing. And committees not only consisting of people from within the temple trust or the families that were initially in control of the temple trust, but specially appointed individuals, either by the court or the government. This is open to debate, but there should be independent committees, especially for large temples. And also, to avoid the clutter, to avoid the extended bureaucracy by adding committees. Since many temples come within the same ambit of certain denominations, you can have common boards. Now, of course, I would, of course, hand it back to you on this aspect. And
Great. Okay. So I think Satya wants to come in, and I think there's probably a response in there. I think you have to unmute yourself. Yes.
Yeah. So one point what Shubhendu and Satvik was talking about, mismanagement by in the boards. I will talk about one petition which I've personally filed and personally witnessed. I had filed a PIL in Andhra Pradesh High Court on checking the constitutionality of the AP Endowments and Charitable Institutions Act, and through which the TDD board gets existence. So one thing I have seen in that, there's one particular section in that particular Act 117, which is called Accounts and Audits. And before coming to that, let me tell you, the annual hundi collection of that particular temple is of 5,000 crores. Only the hundi collection. Okay. Coming back to the section 117 of the Act, what it says, first of all, the head is a government official. Okay. Now, for that particular temple, for that particular Act under section 117, government will appoint anyone, no qualification given, anyone to do an audit of that temple, of the ornaments and money and everything. Now tell me one thing, head is the government is appointing an auditor. How will mismanagement be proved? He will do something or the other and say that there's no mismanagement. So my point with respect to that, we had two relief in our petition. One was certain sections are ultra virus, and second was have an independent audit under CAG or an SIT or any other board, any other committee or board set up by the courts to investigate past 5 financial years of audits of temples or of that board TDD. And we have actually gone really far and now getting our relief in court. So that is of some. We'll talk about that later. But this is one which concerns me. If government is taking over temples, they are appointing their audits, and in most of the acts there is no place for any independent or transparency or any audit under government control. So where is the proper management and public interest coming when government is taken over temples? Samely, we have a petition in Supreme Court. It's on challenging certain section of the Travancore Act of Kerala. So samely, there was a report which was filed by us, and that particular report, the head was retired Supreme Court judge. It consisted of 3 people. I don't remember 3 judges, but so that particular report explains the corruption and non-transparency of the board, of that particular board, where the head is the government official, and that particular board is doing. So that is currently pending in Supreme Court. So that is my whole point. If government is also not able to do proper management, and you feel that a denomination or that particular or who had that temple control earlier, they are also not doing proper management, then who should control the temples? I don't think so. Judiciary should interfere in controlling the temples for short matter of time. Sure, they can, but for a larger aspect, how can they control temples? For that, I'll emphasize again, a district-wise committee where head should be the temple chief, which is the head priest, and subsequently we can also have people from Hindu Mahasabhacharya and people from esteemed Hindu organization who have expertise over this matter coming and giving their inputs how to manage temple. So that, I think so, has to be seen apart from distinguishing between secular religious activities of where government can interfere and government cannot interfere. So that, I think so, it's very essential apart from all other aspects.
Okay.
Thank you.
I think this gets us back to the initial point. Shubhendu, I'm going to come to you only. This gets us back to the initial point that you had begun on. So I'd like to get Shubhendu's views on this. And then we've neared an hour. So then we'll also start taking questions from the audience. Shubhendu, please.
So I have just one quick point to make. I mean, temple property is a temple property. The government should have no control over temple property. One, this should be very clear. Temple's income is temple's income. The government cannot come and interfere into temple's income and appropriate it. So whatever the temple holds as its property, or whatever be the revenue of the temple through donations or whatever means, should vest with the temple trust only. Irrespective of what happens in the country, whether, because I would like to take from where Satvik left, that even if it is 5,000 crores or even if it is 1,000 crores income of a temple, I think the government has no business to go into it and take the money for welfare activities. Of course, the citizens of the country are paying taxes for welfare and every other thing that the government is doing. Temple property, temple income should not be touched for any of these things. It's exclusive to the temple and it is exclusive to the Hindu faith. Hindus should be the ultimate beneficiary. People who have belief in that, people who are associated with the temple, people who have belief in the temple, in that deity, or people who come under the confluence of the temple and its activities, they should be the beneficiaries of these temple properties. The state cannot dictate who should be the beneficiary. So that is one quick point that I wanted to make on this aspect. The other aspect that I will just touch upon is that while the state has no business to take or appropriate the temple property or the income, well, in cases of mismanagement, I think people would be left with no option but to go to the courts. And that is where the role of the courts, role of the judiciary comes into picture. That when there is a mismanagement in temples where the Shabites are not able to handle it properly, or there is a mismanagement on their part, one, or there is a mismanagement on the part of the trust body, then of course the courts will have to come into picture. The courts will have to take the matter in session and then devise a way forward. So yeah, these are the 2 points that I wanted to.
Yes, I think that's extremely relevant, and that sort of ties back to what Satya had also mentioned. Now, an interesting point that I want to bring in here for our viewers, and sort of tying together what all 3 of our panelists are suggesting, that while one, we don't want the government appropriating property and income belonging to the temples, and 2, if at all there is mismanagement by the trust or the Shabites or the body that governs the temple, which is not the government in this case, then you have a recourse to the at the courts. Then the courts would be the appropriate forum to ask for relief in that regard. But the interesting point in terms of what the present status in this regard is, that many trusts are governed by, or many such boards are governed entirely with government control and government scrutiny. And it is for that purpose that we see people moving to the courts to first sort of removing that government control, setting up a new system, and thereafter sort of setting up an independent trust or a mechanism which can then again be challenged before the courts at a later stage. But the important part that I want to add on here is, while I understand it, even in the case of mismanagement, you can see some sort of corrective measures coming into place. The point here is that how can we justify the complete takeover? And I'm talking about the Char Dham Act, the Uttarakhand state legislature has passed. To a large extent, that has been upheld by the Uttarakhand High Court, right? Suggesting that this is done in public interest and the states have a right to sort of take over. Certainly, the view that they've built upon is the Shirur case, right? That again, the people here are sort of not a religious denomination that control the sort of coming. But my question here is one, certainly I think this has been brought up already in terms of perpetuity. But second, complete control. I can understand that the secular function within, again, oppression is pertaining to what? It's the secular function in most cases. Right? When you talk about sort of mismanagement, again, I'm mixing oppression and mismanagement. But when we talk about mismanagement of religious trusts, problem that arises, okay, fine, there can be some relief. But does that mean to get rid of that mismanagement, the government completely takes over effectively the entirety of the possibility of any function that that is related to that particular temple or sort of cluster of temples? Yes, Satya wishes to come in on this.
Just one point. If you see the act, there is in the second section is the definition clauses, right? If you read the definition of Char Dham, which the government is taking over, they have mentioned we are taking over all properties, any or all movable, immovable properties. We will use them for decoration. We will use them for rejuvenation. We will use them for all kinds of activity, all service and all kinds of activities. And is this not complete takeover? Then what is this? And even in the judgment, I think so the High Court erred while giving while pronouncing the judgment, which I think so we'll soon challenge it in the Supreme Court. And talking about one thing, what Shubhendu said is about temple income and temple property. It belongs to the temple. Absolutely, it belongs to the deity. And at no point of time, government should use that property. Also in the Tirupati matter, there have been certain allegations allegedly they are using for non-Hindu purposes. That also has to be seen and looked into if they're using that. Just I just had to add that. Please go on.
Okay.
I would like to add a small point. I would like to add a small point.
Yes.
There's no doubt the government has no right over someone else's property. And in this case, the property belonging to the temple board. And neither does the government have the right to take over such temple boards. But, and like Shubhendu said, that we have to look at individual cases. When we are seeing mismanagement, what recourse does the person have in India, apart from the courts of law? Would you write a letter to the Prime Minister? Would you go to the Supreme Court and ask them to adjudicate? Now, in such situations, my opinion, only in such situations must they constitute external boards that have members of the existing board as well as external members. Like in any mismanagement case in India, in any case of mismanagement, what is the solution that the court gives? It is to constitute a separate committee, which is an independent committee, which will have members from the old committee as well as new appointed members. In other opinion that I would like to stress, yes, the money that the temple makes, the revenue that the temples have, as well as the assets that the temples already possess are the temple's property, and it is for the people who worship that particular faith, no doubt. But in a way, temples should do something like CSR. Of course, you can't call it corporate social responsibility. But if the government or the sovereign or the courts are not going to disburse those funds, in a way, it is important that temples should be regulated to do a certain amount of social responsibility. And since the funds that they accumulate are not only from within the districts that they operate within, but from across the country, look at Tirupati. It's not only people from Madurai who go to Tirupati, but the entire country goes. It is a duty of these temples, a social duty, which Hinduism's core belief, a social duty to the community. I'm not saying do it for everyone, do it for the community at least. There are poor within the community. Use those funds, use those things to help the community. And that is all I would like to add.
No, I think that's an extremely valid point, Satvik, because at the end of it, the idea of faith and the idea of sort of religion is to make man's life better, right? And sure, there are spiritual.
Are they handling mosques?
again, we will
Are there-
get to this. We will get to this. Sure, there
Yeah.
is an important aspect Satya raises, that when we talk about state control, Shubhendu, Satvik, I want to sort of just qualify what Shubhendu said. And Shubhendu, please correct me if I'm wrong here. His point was that state should not have any role. The courts will decide if at all. If you believe that those who are managing, and if there is mismanagement, then courts are your sort of place to go to rather than the government. And I think it's not like you're in disagreement with that. But again, before I get to the first question that I'm taking from the audience, and we will return to sort of other aspects as well, an important part, and I just want to address this. Our panelists, if they wish, they can comment on this, is the fact that when we talk about all are equal before the eyes of law, the question is that are all religions also treated the same way, right? Sure, there are certain specific protections within the constitution of minority institutions and educational and cultural rights, both linguistic and sort of religious. But at the same time, when we talk about control, we see that there is a varying degree of independence across different religions. This is the reality of times. And well, I want that if you wish, Shubhendu or Satvik can also sort of stress upon this. But before we get to that, the first question that I wish to take from the audience, and we'll try to get that up on our screen, and I would first pose it to Shubhendu. The question is by Mr. Yash Dutt. The question is, and I'll read that out for the benefit of all. What is the reasoning behind the ERP doctrine devised by the Supreme Court? Do you think it needs revisiting? Again, so for the benefit of our viewers, we're talking about the essential practices or essential religious practices. That's what ERP here stands for. And Shubhendu, we'll begin with some comments from your side if you'd like to address that, and then we'll see if other panelists want to comment on this.
Yeah, I think the doctrine of essential religious practices is a very important factor in determining what exactly constitutes the practice of religion. Now, one cannot have an essential practice. One cannot have a practice which is detrimental to the society at large, or is against public order and morality. But one can have these, if I can use the word, I mean, one can have these practices protected under essential religious practices, and only if it qualifies as essential. Now, I'll cite just two cases wherein the essential religious practice doctrine was discussed at large. One was Muhammad Hanif Qureshi versus State of Bihar, wherein the petitioner challenged the decision of the government of not allowing cow slaughter during Bakrid. He said that it is essential part of his faith to slaughter cow during Bakrid. Now, the courts went into the details of the religion, they read scriptures written by scholars, and they went into the practices as written in Quran and Hadith and all those documents, and found that it is not an essential practice of the religion to slaughter cows on Bakrid. So that is why essential religious practice doctrine is essential. That is why it is required, because tomorrow people can come with any fancy that comes to their mind and say that, oh, it constitutes the essential religious. It is a part of my religion, and that is why I should be protected, and I should be doing it, and the same practice shall be protected. So, well, it is important in that aspect. Two, the second case that I wanted to talk about is the Shairanabhanu case, wherein again it was claimed that triple talaq is an essential practice of the religion of Islam. And in that also, the court again went into the scriptural basis and decided that no, triple talaq is an irregular method of practice. It's an irregular practice of Islam. It is not essential to the belief, because many of the Islamic countries did not have this. Well, if many of the Islamic countries do not have this, it cannot be an essential practice. And also, it does not have a scriptural basis. The practice does not have its basis in the scripture. So that is how, again, it was decided that it is not an essential practice to the religion of Islam. So these are the two important points that I wanted to bring in, the two important cases that I wanted to bring in to explain why exactly is essential religious practice doctrine required. And do I think it needs revisiting? I don't. I see it is an ever-developing concept. So while people would come up with ideas that they think is essential to their religion, I think the courts can should not have any problem in adjudicating on those issues, following the doctrine of essential religious practices. Revisiting is not required. What is required is that the courts can then just check whether whether a certain practice falls within the ambit of essential religious practice or not. So I don't think revisiting of this is required, because the law has been crystallized in this regard.
Yes, I think that's the core point. And if I were to sort of get the crux from Shubhendu, on some level, when we talk about public order, when we talk about morality, when we talk about 14, 19, and 21 being upheld, to some extent, the ERP doctrine sort of goes hand in hand with that. Right? There's only a limited body of sort of these rules or doctrines, and not anything outside of it. The sort of test in that sense, if we sort of draw from sort of even American jurisprudence, is that okay, if tomorrow I were to say sort of killing people is part of my religious faith, would I be allowed? Or if I were to sort of just start any random faith, I'm nowhere, right? I think Satya wishes to come in on this. So, Satya, if there's a specific point,
yeah, I have a very specific example which will answer Mr. Dutt's question. That is, during the Ram Mandir hearing, the advocate from the Sunni Waqf, they raised one issue that 1994 judgment Ismail Faruqi should be re-examined whether it has to go to a larger bench or not. And for people who don't know what Ismail Faruqi 1994 judgment was, that was basically in his paragraph 82, it said that mosque is not an essential part of Islam religion, and namaz can be read anywhere, even in the open. This was in the paragraph 82 of the judgment, and that it was challenged for a larger bench. 2018 SC AIR 5134, the judgment says that there is no need to examine it to the larger bench. And though there were two statements of that particular judgment in 1994, which the judge said that it cannot be divorced from reading that two judgment, that mosque is not an essential part of Islam, and it does not have any immunity from accusation of government if government wants to under 300A. If you want immunity from that accusation, you have to prove that you've been hit by Article 25 or 26. So I hope that. Yeah.
No, an important point. No, I get your point there, but an important point, if you go back to Justice Bhushan's judgment, said that again, it was in the context of specific public interest. That we were looking at a development construction project in that regard.
Right.
So it's not a blanket.
Absolutely.
Absolutely.
There's no blanket whatsoever. As Shubhendu also said that, this is a very developing law, and there's no point of revisiting it together. But again, as you see different aspects coming into court, it keeps on developing. So I completely agree with Shubhendu on that aspect.
So, again, we're getting in a lot of questions. And obviously, because of time constraints, we won't be able to take all questions from the audience. But because I mentioned these two aspects at the beginning, I will be sort of asking our panelists about it. These two aspects, and we'll take sort of opinions from all of you regarding both these questions. We begin with Shubhendu. I'll get Satvik on board, and then Satya will come to you. Okay, the two aspects that I want comments on, and this is how we're sort of drawing the discussion to a conclusion. First being the question, which is the seventh issue framed for the 9-judge bench, which we touched upon earlier. There's the question of whether someone who does not belong to that faith can challenge the practices within that faith. Right? So this is the first part. Second part, because we've discussed denomination, we've discussed the idea of sort of the rights of a denomination or a section thereof. And Shubhendu also began on this point, the very first statement that he did make, was the question of the Shirur Math case. Now, one aspect is, if I were to draw from Mr. Palkiwala when he spoke of during the Keshavananda case, he said, obviously Golaknath is going to be overruled. Otherwise, what's the point of setting up a 13-judge bench? Now we have a 9-judge bench coming up here. And Shirur Math is a 7-judge bench case. So two aspects I want to bring in, and because they are being considered in that sense. This is going back to where we started, the 9-judge bench. And the bench will be reconstituted, no doubt. One is a question, if people are not part of that faith, should they be able to challenge it? Right? Individuals. Again, I believe that on some level we have the state, which we assume not to have a religion. Again, there's a different debate on secular versus freedom of religion. That's another debate altogether. But one, can individuals challenge this? Because this is, in effect, an issue before the Supreme Court of India. And two, would it be the case that the Shirur Math principle, specifically not just to religious denomination, but even otherwise, on other aspects of law, is to be reconsidered? So, Shubhendu, we'll begin with you on that point. Then we go to Satvik from there.
I'm sorry, I just got disconnected a while ago, and so I could not hear the entire question. So I have the first question with me, but can you please shorten it for me? I mean, can you tell me what exactly?
The two aspects that we're looking at, one is people who don't follow a religion, if they can challenge a religious practice.
Yeah.
The seventh issue before the 9-judge bench. And the question of sort of denomination, because that is effectively also that will come into play, because the 9-judge and this is 7-judge Shirur Math judgment. Will that be challenged? Are there principles within it that require to be reconsidered or revisited now that the court has set up a large bench looking at the broader aspects? So these two aspects, your sort of closing remarks on these two questions.
Okay, so I'll be very quick with my remarks. The first question as to whether somebody who does not practice a particular religion but wants to intervene in that matter, I think that person does not have a locus in such cases. If I am a believer, if I believe in the religion and its tenets, well, then only I should be allowed to challenge the particular any practice of that religion. If I am not a believer, well, then I'm not affected. And the fact that I'm not affected does not grant me locus to intervene in such matters. So this is with regard to whether people who are outside the faith, can they intervene in matters like these. The second question, again, I'm going back to my opening remark wherein I said that if something which is discriminatory, of course, when something which is discriminatory, 14, 19 and 21 come into picture, any person can approach the court. And that includes people from the outside. But when it comes to essential religious practices and tenets therein, I think the government, the people outside do not have any role to play unless there is discrimination. The second point about denominations is that we have to understand that Hinduism in itself is a very vast religion, has multiple belief systems, and people have different ways of offering prayers or worshipping. Different mutts have different ways of worships, and the practices in North India is very distinct from the practices in the South India, or practices in Bengal is very distinct from practices in Kerala, religious practices. In that situation, what does one do? Well, it is there that the whole issue of denomination comes into picture. Now, we cannot have a blanket set of practices. I mean, we cannot have a blanket protection to a certain set of practices, which people in the North India claim to be very essential to the practice of Hinduism, and which may not be so in case of South India.
So in that situation, the whole issue of denomination comes into picture, and that is where the protection can be granted to the denominations. Let us go back to the Shirur case. Why it was why it came into picture was because of the protection of the practices and of denominations which were distinct from what was there in other places of worship. So, well, if given the diversity of practices, given the diversity of mode of worship, denominations can claim protection of their practices. That is what is my take on the whole issue of denominations, protection of the practices, essential religious practices of the denomination.
Certainly. Thank you, Shubhendu. Satvik, quickly, your closing remarks on these two aspects.
Okay, first off, when we look at religious denominations, it is important to note that in an earlier point that I had made, now you cannot make, like when we discussed Syrian, I did not say Christian women, I said Syrian Christian women. Now the entire aspect of Mary Roy was that Syrian Christian women were not separate from other Christian women. So if other Christian women are subject to the Indian Succession Act, why are Syrian Christian women subject to a different act? That is single class legislation and violator of 14, and there is no intelligible differentia over there. The similar view was adopted by Justice Nariman in the Sabharwal case, where he said that people who worship Lord Ayyappa are not a separate religious denomination. They are Hindus who are worshipping Lord Ayyappa. Now, when he says that, that means that you can't say that there may be 1,000 Ayyappa temples, but one is a Brahmachari idol. Hence, 999 temples women can enter and one they can't, because again, the worship of Lord Ayyappa is not a separate religious denomination. So that was the understanding and the morality aspect that Justice Nariman took. Now, when we look at interference of the government within religious aspects, we have to take into, my personal opinion is that if something is designated as an essential religious practice, no one has the right to challenge it. Whether it is the person practicing that religion or whether it is a person from a different religious denomination. That is only and only if that particular aspect has been designated as essential religious practice. But if it is not an essential religious practice, then like we have already discussed, then it must stand the test of constitutionality, which is 14, 19, 21. Now, I'll give you an example when we say people from other faiths cannot file petitions challenging a religious practice. How can we say that? When if that particular religious practice affects someone from a different faith, like I'll give you an example. The use of loudspeakers is actually deemed as a hindrance. It's not an essential religious practice to Islam. Several high courts and even the Supreme Court have ruled on this. Now, are you saying that a Jain person or a Christian person or a Hindu person affected by that loudspeaker every morning at every day at 4 in the morning cannot file a petition against that? Is that not a violation of his right to life under Article 21 to live in peace? Similarly, when you talk about immersion of idols into rivers, today, of course, majority of them are biodegradable and environment-friendly idols. But the immersion of idols into rivers in the past has caused pollution, river pollution. Is that not something that is affecting society as a whole? And is that essential to your religious practice? So if something is not essential to a religious practice, but it is practiced, then everyone should have the right to challenge it if that particular practice in any way is harming anybody. But if it is an essential religious practice and nobody is getting affected by it and it is recognized as an essential religious practice, then no one has a right to challenge it. No one has a right to interfere. No one has a right to control it in any way whatsoever. It is an essential religious practice. So on these two aspects, this is my opinion.
Okay, great. I think so. In a sense, Satvik is evolving that part further, that on some level, you might not be part of the religious community, but there can be something that affects the community at large. So I think what he's drawing on is the harm principle. That if I'm not even part of the religion, but I'm being in some sense being affected adversely, then I should have that sort of locus
right to challenge.
Yes. So in effect, he's not disagreeing with what Shubhendu is saying, but he's saying that there can be this sort of qualification that can be made in the broader public interest. So again, this sort of flows from either health, morality, order, etc. So we'll quickly get to Satya, his final comments on these two aspects, and he sort of briefly touched upon this. But if this, along with anything else that he wishes to add briefly, and then we'll sort of bring our discussion to a close. Hello. I think we're having some difficulty with,
In terms of essential practice, yes. If it has been established, then there should be no intervention with respect to that. When this particular the definition of denomination, yes, it has to be challenged, or the 9-judge bench can lay down a new definition of denomination, and broadly this. And in the end, I mean, I've expressed all my views, but in the end, I would like to say one thing, is that I like to extend my wishes, my greetings to everyone out there, and for the upcoming Ram Janmabhoomi Bhumi Pujan on 5th of August and 12 p.m. 15 minutes and 15 seconds. Jai Shri Ram.
Okay.
Thank you.
Okay. So, thank you so much for that. I think, but before I bring this discussion to a close, I think we leave with all three of our panelists coming to the same page on multiple issues. And at the same time, there are still questions that remain to be answered. Sure, courts cannot get into the questions of ERPs. What about the state? What about Parliament? What about them passing a law? What about those laws sort of extending it further? What about those laws then being challenged before the Supreme Court or various higher courts? So I think the discussion, debate will sort of go on in this. We've extensively talked about these in other constitutional issues, and we here at the IYEA will continue to bring to you content, well-researched content from people with practical experience and having sort of read up on these issues, on constitutional issues. And that is a plan. We've been doing this over the last, I think, at this point, few years now. And once again, we'd like to thank all our panelists. For everyone tuning in, I understand there's some very interesting questions still coming in from Arudra and from Ashish. And it's unfortunate that we won't be able to take all of them. We've sort of gone past the 1.5 hour mark. But certainly you can write to us with these questions, and this conversation is supposed to sort of go on forever. As Shubhendu began by saying that on some level, our idea is that the narrative should be one that is scholarly, that encourages discussion of opinions that are not brought about or have not been sort of talked at length. Right? The idea of sort of conventional wisdom is that, again, it shouldn't be only conventional wisdom. We have to sort of expand the scope of discussion that we're carrying out. So having said that, we will continue with discussions on constitutional, legal, commercial laws as well, including other economic and historical issues that we do discuss at all times. Once again, many thanks to all of our panelists. And just a sort of short pointer that I'd like to end with, though all of you have tuned in together here today for the IYEA's discussion on this, and though we're not involved particularly in terms of organizing or otherwise, I believe on the 5th of August, I think in the evening at 5:30, Shubhendu will be having another session dealing specifically with Mr. Vikramjit Banerjee, current ASG, the Supreme Court of India. So all of those who are interested in this topic, and again, it's a related topic, it's not exactly the same one, but if you're interested in the line of the school of thought, and if you enjoyed the discussion with Satya, Satvik, and specifically Shubhendu, please feel free to sort of join with that as well. Once again, everyone, thank you so much. I'm supposed to say this because I've been instructed by my team of interns. Please like, share, subscribe our content all across different platforms. For whatever good work we do, the idea is for it to reach the largest possible audience. That's only how we will be doing justice to the content that we are creating. So thank you so much, everyone, once again. It was a pleasure having hosted you. And we'll continue with this kind of content in the future. Bye-bye.